It was the spring of 1945 and the war in Europe was not yet over. The Rhine had been crossed, the Wehrmacht was falling back in fragments. American armor was pushing deeper into Germany with each passing day, and the men of General George S. Patton's Third Army had not stopped moving since the hedgerows of Normandy. But on a cold morning in a forward aid station somewhere west of the main river, something happened that had nothing to do with armor or artillery or the grinding mechanics of a military advance. What happened was smaller than that, and in its smallness, it revealed something about power, about law, and about the kind of man George Patton actually was beneath the polished helmet and the rhetoric. An SS officer raised his hand against an American soldier, and Patton found out, if this is the kind of history that matters to you, a stories where the record actually holds up, where the details come from documents and memoirs and unit logs rather than myth, then subscribe to this channel and leave a like before we go further. Costs you nothing and it tells us this work is worth continuing. To understand what happened in that aid station, you need to understand where the Third Army stood in the first weeks of March 1945 and what the atmosphere was like among the men who served in it. General George S. Patton Jr. had commanded the Third Army since its operational activation in France on August 1, 1944. In 7 months of continuous combat, the army had advanced farther, faster, and with fewer men per mile of front than almost any comparable formation in the European theater of operations. By early March 1945, Third Army had liberated or seized portions of France, Luxembourg, Belgium, and now stood pressing into the German heartland itself. The army's composition was vast. On any given day in March 1945, Third Army controlled between 12 and 15 divisions, a mix of armored, infantry, and mechanized cavalry supported by corps and army artillery, engineer battalions, signal companies, quartermaster units, medical battalions, and hundreds of thousands of individual soldiers, most of them between the ages of 18 and 26. The front was moving. That was the critical fact of that period. A moving front created a particular kind of chaos. Units that had been fighting for months were stretched thin across roads and rivers. Supply lines ran hundreds of miles back toward Antwerp and Cherbourg. German resistance varied wildly. A hamlet might fall in 20 minutes. A crossroads might hold for 3 days. And in the spaces between organized combat, prisoners were moving in one direction, while replacements moved in the other. Among those prisoners were members of the Waffen SS. By March 1945, the Waffen SS had been fighting on every German front for years. Its units, the 1st SS Panzer Division Listander, the 2nd SS Panzer Division Das Reich, the 12th SS Panzer Division Hitlerjugend, and dozens of others had accumulated a record of both tactical effectiveness and systematic atrocity. The massacre at Malmedy, the previous December, in which soldiers of the 1st SS Panzer Division had murdered 84 American prisoners of war at a crossroads in Belgium, had produced in American soldiers a particular kind of awareness about what it meant to handle SS prisoners. That awareness was not always clinical. The Geneva Conventions of 1929 governed the treatment of prisoners of war. The United States Army as a signatory power was bound by those conventions. This meant that prisoners, including SS prisoners, were entitled to medical treatment, to food, to shelter, and to protection from violence. It also meant that captured enemy soldiers could not be compelled to do work that directly supported combat operations against their own forces. These were not suggestions, they were the governing law of land warfare. American medical units operated under a different and more ancient provision, the Red Cross marking on a helmet, a vehicle, or a building identified a protected zone under international law. Medical personnel were non-combatants. Aid stations were supposed to be neutral ground. The men who staffed them, the medics, the surgeons, the litter bearers operated under the assumption that their status as medical personnel protected them. That assumption in the spring of 1945 was being tested daily. The precise location of the aid station in question sits in the historical record with the ambiguity comment, a small unit events in a fast-moving campaign. What is documented is the nature of the incident and its immediate aftermath. The context places it in the zone of Third Army operations in the weeks following the crossing of the Moselle and the Poche toward the Rhine and beyond. The American battalion aid stations in 1945 were not hospitals, they were collection points, the first organized medical element behind the front line. A typical battalion aid station was staffed by a battalion surgeon, usually a captain, and between 4 and 8 medical enlisted men. It operated out of whatever structure was available, a farmhouse, a cellar, an abandoned school, or simply beneath the shelter of trees if no structure existed. Its function was triage and stabilization. Men who arrived there were assessed, treated for immediate life threats, and evacuated rearward through a chain that ran from aid station, the collecting station, to clearing station, a field hospital. The men who staffed these stations were not combat soldiers in the conventional sense, though by 1945, most of them had seen as much of the front as any infantryman. They wore the Red Cross. They carried no weapons or in some cases a sidearm, permitted by Army regulation. They were trained to work under fire and many had done exactly that. When German prisoners arrived at or near American aid stations, whether wounded, captured in the immediate area, or passing through under guard, they were to be handled according to the conventions. Wounded German soldiers were to receive the same medical attention as wounded Americans, prioritized by severity of injury. This was not a courtesy. It was a policy enforced at every level of command. On the morning in question, a German officer and officer of the Waffen SS identified by his collar, insignia, and uniform markings was in the vicinity of an American aid station. The circumstances of his presence vary slightly depending on the account, but the central fact does not. The SS officer struck an American medical soldier. The blow was an open-handed strike, a slap delivered across the face of the American who was in the performance of his duties as a medic. The American soldier did not retaliate. He was outranked, unarmed in the immediate sense and in the presence of other prisoners and guards. He reported what had happened. The report moved up the chain. George Smith Patton Jr. was 59 years old in March 1945. He had been a soldier since his graduation from West Point in 1909. He had served in the punitive expedition into Mexico under Pershing in 1916, had commanded a tank brigade in France in 1918, and had spent the interwar years studying armor, writing doctrine, and cultivating the persona that would make him by 1940 for the most recognizable American ground commander of the war. He was also a man of sharp and sometimes violent temper, a fact that had nearly ended his career in Sicily in August 1943 when he struck to hospitalized soldiers he believed were malingering. The incident is what became known as the slapping. Incidents had cost him command for nearly a year, had nearly resulted in his permanent relief and had been resolved only through the intervention of Eisenhower and a combination of public apology and reassignment. Patton knew therefore precisely what the public and his superiors thought about officers who struck enlisted men. He had lived through the consequences. He had written about it in his diary with characteristic bluntness, acknowledging the act, defending his intent, and recording his awareness of the damage done to his reputation. By March 1945, Patton had been restored to command and had led Third Army through 9 months of some of the most demanding mobile warfare the American Army had ever conducted. He was by any operational measure performing at the peak of his career, but he was also aware that he remained under scrutiny, that his conduct was observed, and that another major disciplinary incident could end him permanently. When the report of the SS officer's action reached him through the normal chain of command, amplified by the particular sensitivity of anything touching on prisoners and the laws of war, Patton's response was immediate and unambiguous. He ordered the SS officer brought to him. What followed has been recorded in several accounts, including the recollections of staff officers who were present or who received direct reports of the exchange. The accounts are consistent in their outline, though they differ in some particulars of language. The SS officer was brought before Patton. He was not in a formal setting, not a courtroom, not a headquarters conference room with stenographers and legal officers. He was brought to wherever Patton happened to be at that moment, which was the forward command post of Third Army, a working space that reflected the pace of the advance. Maps on tables, radio operators at their sets, staff officers moving in and out. The SS officer, by some accounts, carried himself with the particular bearing that was common among senior Waffen SS personnel, an erect posture, a refusal to display difference. Whether this was genuine composure or calculated performance, for the benefit of his captor, is impossible to determine from the historical record. What is recorded is that Patton did not raise his voice. Patton, through an interpreter, informed the SS officer of what he was alleged to have done. The officer accounts differ on whether he denied the act or offered some form of justification. Reportedly maintain that the American soldier had not shown appropriate respect or had in some way provoked the incident. The precise words are not uniformly recorded, but the substance is the SS officer did not offer an unconditional admission of wrongdoing. Patton's reply, according to the accounts that have come down through Third Army staff records and the memoirs of officers present or informed, was direct. He told the SS officer, and this is the part of the exchange that has been recorded with some consistency, that under the laws of war, the officer had committed an act against a protected non-combatant, that the Red Cross marking of a medical soldier represented not merely American military regulation, but the binding conventions of international law, which Germany had also signed, that regardless of rank, regardless of unit, and regardless of whatever contempt the officer held for American forces, he had placed himself in legal jeopardy by that single act. Then Patton did something that the SS officer almost certainly did not expect. He did not strike him. He did not order him shot. He did not have him beaten or humiliated before the assembled staff. He had him formally charged. This is the part of the story that tends to be overlooked in popular accounts because it is less dramatic than a physical confrontation and less satisfying than a summary act of vengeance. But it is in many respects the more significant part. By 1945, the United States Army had developed a substantial body of legal machinery for handling violations of the laws of war. Judge, advocate, general officers, military lawyers were present at corps and army level. Procedures existed for documenting incidents, gathering witness statements, and preparing cases for review. The Geneva Convention itself specified that violations were to be investigated and, where evidence supported it, prosecuted. The SS officer's act striking an American medical soldier in the performance of his duties was a violation of Article 2 of the Geneva Convention relative to the treatment of prisoners of war, which required that prisoners treat the personnel of the detaining power with respect, and of the broader provisions protecting medical personnel under the 1929 Geneva Convention for the amelioration of the condition of the wounded and sick in armies. In the field, Patton directed that the matter be referred to the Judge Advocates section of Third Army for formal documentation. Witness statements were taken. The SS officer was identified by rank and unit. The American medic provided his account. The physical act was documented. This process mattered for reasons beyond the immediate incident. The spring of 1945 was, though no one could be entirely certain of it at the time, the final weeks of the European War. Allied planners and legal officers had been working for months on the frameworks that would govern the treatment of German war criminals after the Armistice. The London Charter that would establish the International Military Tribunal at Nuremberg was still months from completion. It would not be signed until August 1945. But the underlying work was already underway. Individual incidents, like the one in that aid station, were part of a larger pattern of documentation. The Malmedy massacre had already generated an extensive investigation. Atrocities committed by SS units against French, Belgian, Dutch, and Soviet civilians had been documented by Allied intelligence for years. The formal charging of an SS officer for an act against a non-combatant American soldier was in its small way part of the same evidentiary practice that would eventually produce the Nuremberg trials. Patton understood this. He was not a lawyer, and he did not express himself in legal language. But his instinct is to use the law rather than to bypass it reflected something important about the kind of war the Allies were trying to fight and the kind of post-war world they were trying to build. It would be a mistake to present Patton as a consistent or uncomplicated advocate for the laws of war. He was not. His record on prisoner handling was genuinely mixed. He had on at least one occasion in Sicily made remarks that were interpreted and documented as implying that German and Italian prisoners need not always be taken. The so-called Biscari massacre of July 1943, in which American soldiers killed the prisoner after a combat engagement occurred within the area of operations of Patton, 7th Army, and the subsequent investigation and courts-martial took place under his command. The handling of those cases in which one sergeant was convicted and later pardoned, another acquitted, raised serious questions about the command climate in 7th Army regarding prisoner treatment. Patton's diaries and correspondence from the period contain passages that reflect both his awareness of the laws of war and his impatience with their constraints in the heat of combat. He was a man of genuine contradictions, capable of ordering the formal prosecution of an SS officer for striking a medic while simultaneously expressing in private contempt for the procedural limitations that slowed his army's advance. What is consistent in his record is not a principled commitment to international humanitarian law as an abstract value. What is consistent is his acute awareness of command responsibility. He knew that what his soldiers did reflected on him, that what happened in his army was his responsibility, and that the discipline of his force, including its discipline in the treatment of prisoners and non-combatants, was a measure of his command. When the SS officer struck the American medic, the insult was not merely to the soldier, it was to the United States Army, it was to the Red Cross, which represented a standard that Patton's army was supposed to uphold, and it was in Patton's calculus an insult to him personally because he commanded that army and because what happened to one soldier in one aid station was ultimately something he was responsible for addressing. The formality of the response, the legal referral, the documentation, the formal charge was Patton managing his command responsibility the way a senior officer was supposed to manage it, not with a slap of his own, which would have been both legally problematic and personally ironic given his history with the machinery of military law. To fully appreciate the weight of the incident, it is worth spending a moment on the Waffen SS itself in the spring of 1945 and on the specific culture and training that produced the officer who raised his hand in that aid station. The Waffen SS had been formed as the armed wing of the SS organization in the late 1930s and had expanded dramatically during the war, reaching a peak strength of approximately 900,000 men. By 1945, organized into roughly 38 divisions of varying quality and size. Its senior formations, the so-called Panzer divisions of the ISS Panzer Corps, were among the best equipped and most experienced German units on any front. They had fought at Kursk in Normandy, in the Ardennes, and now in the final defense of the Reich. The SS cultivated a particular ideological identity in its soldiers. Training emphasized not merely military skills, but a specific worldview, one that positioned the SS soldier as a racial and political elite, fundamentally different from and superior to conventional military forces, enemy soldiers, and civilian populations. The conventions of war that governed ordinary soldiers were in this worldview constraints that applied to others. The SS had demonstrated this posture systematically from the execution of commissars on the Eastern Front to the massacre of civilians in France and the Low Countries. By March 1945, however, the practical circumstances of that worldview were collapsing. SS units that had once advanced through eastern Poland with impunity were now retreating through Germany. Officers who had commanded with authority were now prisoners. The psychological adjustment required from occupying power to captive was for many SS personnel genuinely difficult. The arrogance that had been institutionally cultivated did not simply evaporate upon capture. The slap in the aid station was in this sense a small expression of something larger. The refusal of a particular kind of soldier to accept that the world had changed, that the conventions now applied to him, that the red cross on an American medic's helmet meant exactly what it said. Patton's response was the answer the law provided. The American medic at the center of this incident is not in most accounts identified by name. He appears in the record as a type rather than an individual, a medical soldier, an enlisted man, a non-combatant performing his duty. This is a common feature of wartime incidents that involve individual soldiers at the lower end of the rank structure. They are present in the record, not as subjects, but as the occasion for command decisions made by men whose names are better preserved. What can be said about him with reasonable certainty is the following. He was almost certainly a member of a medical detachment attached to an infantry or armored unit operating in Third Army Zone in E. Early March 1945, medical detachments at battalion level were typically drawn from the Medical Replacement Training Center at Camp Parkley, Texas, or similar facilities and consisted of men who had completed basic training followed by specialized medic training. Many of them were draftees. Some had volunteered specifically for medical service. A number of them had no military background whatsoever before the war. By March 1945, any medic serving in a frontline unit had been through a great deal. The winter of 1944 and 1945 had been punishing. The Ardennes offensive had produced American casualties on a scale not seen since Normandy, and the medical system had been under extraordinary strain. A medic who was still in a forward aid station in March had survived the bulge, had worked through the freezing months of January and February, and had seen things that most people never see. When that soldier was struck by the SS officer, he did not fight back. He reported the incident through proper channels. That act, the decision to report rather than to respond with force, was itself an act of discipline. And it was that discipline that allowed the event to become a matter of record rather than a matter of violence. There is something in that restraint worth acknowledging. The American soldier in that moment represented exactly the standard his army was supposed to maintain. He was in the right. He knew it. And he trusted that the system would respond. March 1945 was not simply a military moment. It was a legal moment. Across the Allied world in legal offices and diplomatic missions and intelligence organizations, the work was underway that would eventually produce the tribunal at Nuremberg, the verdicts of October 1946, and the body of international humanitarian law that emerged from the post-war period. The individuals involved in that work: Robert Jackson in Washington, Hirsch Lauderach in London. The legal teams attached to the Allied expeditionary forces were building frameworks intended to establish a permanent principle that violations of the laws of war were not merely military offenses, but crimes under international law, prosecutable by international authority. This was not a settled principle in 1945. It was a contested and evolving one. The German defense at Nuremberg would argue, among other things, that the Allied prosecution was applying law retroactively, that the conventions had never been understood to carry criminal liability at the individual level, and that the victors had no legitimate authority to judge the defeated. These arguments were rejected, but they were not frivolous. They reflected genuine questions about the state of international law at the post-war tribunals were answering for the first time. In this context, the formal charging of the SS officer by Patton's Third Army was a small but real instance of the principle in practice. A violation of the laws of war was treated as a legal matter. Evidence was gathered. A record was made. The officer was not shot in reprisal, was not subjected to summary punishment, was not beaten by soldiers who had every emotional reason to beat him. He was processed by the system that had been created precisely for that purpose. This is not to romanticize what happened or to suggest that every instance of prisoner handling in Third Army met this standard. It did not. The record of American forces in 1945 contains incidents of summary execution and mistreatment that stand in direct contradiction to the standard Patton enforced in this case. War does not produce uniform conduct, and a gap between the stated standard and actual practice was real and significant, but the incident in the aid station and Patton's response to it are part of the record. They happen, and in the specific context of a senior American commander making a deliberate choice to use legal process rather than extraordinary force against an enemy who had violated the law. They represent something worth recording. The spring advance, the Third Army continued its push into the German interior. In the third week of March 1945, Patton's forces crossed the Rhine at Oppenheim on the night of March 22 quietly, without the elaborate preparation and ceremony that preceded Montgomery's crossing to the north. Patton called Eisenhower's headquarters in the early hours of March 23 to report the crossing, and the tone of the call, as recorded by those present, was characteristic, satisfaction barely restrained. By the end of March, Third Army had units in Bavaria. By April, they were approaching Austria. On May 6, Third Army's advance units reached the outskirts of Pilsen in Czechoslovakia, where they halted, ordered to stop by Eisenhower in accordance with agreements reached at Yalta about the zones of post-war occupation. Patton objected. He wanted to push further into Prague if possible, and his objections were noted and overruled. It was one of the few moments in the final campaign when his operational instincts were restrained by political calculation, and it frustrated him deeply. He believed, and he may have been right, that a stronger Allied presence in Czechoslovakia at the end of the war would have altered the post-war political landscape in Central Europe. Germany surrendered unconditionally on May 8, 1945. Patton was present at the end of the war. He had spent his entire career preparing to fight. He was 59 years old. His Third Army had in 9 months of combat liberated or captured approximately 81,500 square miles of territory, taken over 750,000 prisoners of war, and sustained approximately 160,692 casualties killed, wounded, and missing. The war in Europe was over. The legal reckoning was just beginning. The post-war period was not kind to Patton in the ways that mattered to him. He was given command of the 15th Army in June 1945, a headquarters responsible for compiling the military history of the European campaign, not a field command in any operational sense. He was removed from command of Third Army in October 1945 after making public remarks that compared the Nazi Party ordinary political parties, remarks that were widely reported and produced immediate outrage in the United States and among Allied governments. Eisenhower relieved him. It was the end of his active combat command. On December 9, 1945, Patton was involved in a road accident near Mannheim, Germany. A military truck made a turn in front of the staff carrying Patton and his chief of staff. The collision was low speed, but Patton, who had not been wearing a seat belt, was thrown forward and struck the partition of the vehicle. He sustained a fractured dislocation of the cervical spine and was paralyzed from the neck down. He was transported to the 130th Station Hospital in Heidelberg, where physicians worked to stabilize his condition. For 12 days, his wife Beatrice, who flew to Germany immediately upon learning of the accident, was at his bedside. He spoke with her. He read. He received visitors. He was aware of his condition and of its likely outcome. On December 21, 1945, at approximately 17:45 Central European Time, George S. Patton, Jr. died of pulmonary edema and congestive heart failure, a secondary consequences of his spinal injury and the associated complications. He was buried at the Luxembourg American Cemetery at Ham, Luxembourg, among the men of Third Army. At his request, he was interred with the soldiers he had commanded rather than at West Point. The grave is marked with a standard white cross identical to those of the men buried around him, distinguished only by the inscription of his rank. He was at the end among his soldiers, the SS officer whose act in that aid station set these events in motion disappears from the documentary record after the formal charge was filed. What became of him is whether he was prosecuted, whether the charge was subsumed into the broader legal processes of the post-war period. Whether he survived the war at all is not established in the publicly available sources consulted for this account. This is a common fate for the secondary figures in wartime incidents. The principals are documented. The supporting cast is often not. The American medic is similarly absent from the named record. He was one of thousands of medical soldiers who served in Third Army through the European campaign, if he survived, and a balance of probability suggests he did, since the incident is recorded as a completed event without mention of his subsequent fate. He returned to the United States at some point in 1945 or 1946, was discharged and resumed his life. What he carried from that morning in the aid station is not recorded. The experience of being struck by a prisoner, of being subjected to an act of contempt from a man who had just lost everything, and then of watching the system actually respond, watching the report move up the chain, watching the charge get filed, watching the law do what the law was supposed to do, that experience left no surviving testimony. It does, however, leave a question worth sitting with. The men who designed the Geneva Conventions, who negotiated the language of protection for medical personnel, for prisoners of war, for civilians in occupied territory, did so because they had seen what happened when those protections were absent. They had seen it in 1914, in 1918, in the wars before that. They built a legal architecture not because they believed armies would always follow it, but because they believed the existence of the law would change the calculation, that it would give commanders like Patton a procedure to follow instead of an impulse to act on. In the spring of 1945, in a forward aid station somewhere west of the main river, that architecture was tested in a small way and it held. The story of what Patton did when an SS officer struck an American medic is not a story about heroism in the conventional sense. There was no combat, no tactical decision, no terrain to seize. It was a story about command, about law, and about the choice made deliberately in full awareness of the alternatives to respond to a violation with procedure, rather than with force. That choice mattered, not because it changed the outcome of the war, which was already determined by March 1945, not because it rehabilitated Patton's complicated legacy, which remains what it is, but because it added one more entry to the record, one more instance in which the laws of war were invoked, documented, and applied. The Nuremberg tribunals, which opened in November 1945 and concluded in October 1946, were built on exactly this kind of record. Thousands of individual incidents documented, witnessed, charged, processed through legal channels became the evidentiary foundation for the verdicts that established for the first time in history that individuals could be held criminally responsible for violations of the laws of war under international law. The medic who reported the incident, the staff officers who processed the charge, the judge advocate personnel who documented it, they were part of that foundation. They did not know it at the time. They were simply doing their jobs, following procedure, upholding the standard. That is how law works when it works, not through grand gestures. Through the accumulation of individual acts of documentation and accountability, repeated across thousands of incidents, thousands of people who understood that the record mattered, the men and women who served in the Second World War are, as of this writing, nearly gone. The youngest of them are in their late 9s south. The accounts we have are the ones they left us in memoirs and interviews and diaries and unit records and the formal documents of military law. Those accounts deserve to be treated with care. They deserve to be read closely, and they deserve to be remembered not merely as stories of individual courage or command brilliance, but as a record of what it cost in human terms to build the world that came after, That world is not permanent, it was made, can be unmade. The record is the reminder.